So, good afternoon to all. First of all, would like to thank both our speakers and the participants for being here with us. Our thanks also go to the organizing committee of the annual conference of the Knowledge Platform Security and Rule of Law, who gave us this great opportunity to share our work. My name is Stavros Pantazopoulos, and I am the Legal and Policy Analyst of the Conflict and Environment Observatory, a UK-based NGO aiming to raise awareness of the environmental impacts of conflict.
Good afternoon from me as well. My name is Taygeti Michalakea. I have carried out research on corporate accountability and transitional justice, and I'm currently a postdoc fellow at the University of Social and Political Sciences in Athens. The idea for this session is linked to a common project that we are carrying out with Stavros, which is funded by KMF, and deals with corporate environmental responsibility in conflict and fragile settings. Going back to the topic of the present panel, it is quite striking that even though environmental protection is a topic of fundamental importance both for scholarship and practice during the last decades, yet it has not been linked sufficiently with overarching concepts such as security and rule of law. Therefore, our goal in putting together this panel is to reach a common understanding regarding the environmental component of security and rule of law. In other words, what we call environmental security and environmental rule of law. Starting from the former, our assumption is that environmental harm can spill over and cause adverse effects on security. This is the case when lack of environmental protection leads to community relocation and subsequent insecurity, as is the case in various areas of Sudan and South Sudan. Therefore, it is an issue that should be read as an element of human security. Besides, this is why environmental degradation is increasingly characterized as a risk multiplier, both for security and for conflict. It is to be noted also that the United Nations Security Council holds a significant role in this domain and has held two informal meetings on the protection of the environment during armed conflict in 2018 and 2019 in an effort to assert its position in the environmental security field. As for rule of law, it can also be hampered by environmental harm, given that in cases of environmental harm, there is usually inadequate or complete lack of access to justice. For example, this was the case of Vietnamese plaintiffs who brought a lawsuit in the US against chemicals corporations for damage incurred due to the use of Agent Orange, and the case did not come to fruition. Although environmental rule of law is a concept that we plan to elaborate during this session, as a common denominator, it is to be noted that it was firstly used in 2013 in an international instrument by UNEP. Our understanding is that environmental rule of law forms a further specification of the traditional rule of law principle, whereby laws and practices of relevant actors should not only be consistent with international human rights norms, but they should also be inclusive of environmental needs and conducive to environmental sustainability and protection. We perceive it as a concept that is bridging environmental governance with human rights under the overall goal of environmental protection.
Drawing from this reality, we hope that the present panel will further elucidate the intersection of environmental protection with security and rule of law, particularly in areas ridden by conflict. The speakers will approach the topic from different angles, including from an international law perspective, the exploitation of natural resources, and the role of corporations and non-state armed groups in this domain. So we are happy to have with us today three prominent experts on different aspects of environmental protection in conflict-affected areas. Before introducing our first speaker, I'd like to make two important housekeeping points that are primarily addressed to our attendees. First, you're welcome to pose your questions in the chat function throughout the session, but in any event, following the three presentations, we will hold a 20-minute Q&A session where all attendees are encouraged to pose questions directly to any speaker by raising your hands. Second, I'd like to remind you all that this session is being recorded. And now, let me introduce our first speaker, Marja Lehto. Marja is an ambassador and senior expert in public international law at the Ministry for Foreign Affairs of Finland and adjunct professor of international law at the University of Helsinki. She is a member of the United Nations International Law Commission and Special Rapporteur for the topic Protection of the Environment in Relation to Armed Conflicts. Marja will introduce the recent initiatives undertaken by the international community to strengthen environmental protection in conflict settings. And as the UN International Law Commission Special Rapporteur, she will also shed light on its work on the topic and its future outcome. Marja, the floor is all yours.
Thank you, Stavros, and good afternoon. So I have been asked to give a brief overview of the normative developments on conflicts and the environment, and I would like to begin with an often heard phrase, according to which the environment is a silent victim of war. Throughout the history of efforts to regulate warfare, the focus has been on humanitarian protection, and the existing fairly comprehensive body of international humanitarian law is not primarily concerned with the environment. The rules that provide direct protection to the environment are few and substantially limited. What nevertheless has changed in recent decades is that the understanding of the environmental impacts of armed conflicts has developed considerably. This has triggered, as we heard, a heightened political interest in the issue and has also provided the basis for new normative developments. A number of initiatives have been launched in the past 10 years, seeking to compensate for the dearth of specific legal rules on the protection of the environment in and in relation to armed conflicts. The purpose of these initiatives has mostly been to clarify existing international legal rules and to interpret and apply them in an environmentally friendly way. It is not excluded that these developments could lead to the preparation of a binding treaty in the future, but for the time being, this is not in the horizon. These initiatives include the new policy of the Prosecutor's Office of the International Criminal Court, which includes environmental crimes as a priority, and the issuance last year of the Geneva Principles on the protection of water installations. Protection of the environment in armed conflicts has further been highlighted in the draft Global Compact for the Environment, as well as in the draft International Covenant on Environment and Development of the IUCN. A particularly important milestone is the publication this autumn by the International Committee of the Red Cross of the updated iteration of the Guidelines on the Protection of the Environment in Armed Conflicts. The ICRC guidelines present a broad take on how the existing international humanitarian law protects the environment. They are particularly significant in that they reveal the capacity of many provisions, primarily crafted for the protection of civilians, to also provide general or indirect protection to the environment. Another recent development was the adoption by the UN International Law Commission last year of a set of draft principles regarding the protection of the environment in relation to armed conflicts. The ILC draft principles differ in three important respects from the ICRC guidelines, even though both documents share the same fundamental aim of clarifying the international law applicable to conflict-related environmental harm. First, the ILC work is not exclusively focused on situations of armed conflict, but seeks to cover the whole conflict cycle, including pre- and post-conflict phases. The 28 draft principles address armed conflicts, situations of occupation and post-conflict situations, as well as measures to be taken before an armed conflict breaks out. Second, while the ICRC guidelines are a restatement of law as it stands in the eyes of the ICRC, the International Law Commission's work seeks to enhance the protection of the environment within the limits of the Commission's mandate to progressively develop and codify international law. And third, in addition to international humanitarian law, the ILC work draws on other areas of law, such as international environmental law and international human rights law. The ILC topic obviously covers the time of armed conflict, and there are provisions based on IHL rules on the conduct of hostilities, which protect the natural environment from widespread, long-term and severe damage. Most draft principles, nevertheless, focus on environmental harm below that high threshold. Harm that is caused inadvertently or by negligence, harmful practices, and harm caused by other actors than the parties to a conflict. The principles deal, for instance, with peace operations, humanitarian assistance, protection of the territories of indigenous peoples, and regulation of corporations and other business entities. One draft principle requires states and international organizations involved in peace operations to consider their environmental footprint. They shall take appropriate measures to prevent, mitigate, and remediate the negative environmental consequences of such operations. Another draft principle seeks to prevent environmental damage caused through conflict-induced human displacement. Population displacement is a typical consequence of the outbreak of an armed conflict, and one that may give rise to significant human suffering as well as environmental damage, the latter mainly related to the use of natural resources for food and shelter. Altogether, 5 draft principles belong to the broad context of illegal and/or unsustainable use of natural resources and address it from different angles. Draft principles also address issues of responsibility and liability. As you may know, the international law rules on state responsibility are clear in that every internationally wrongful act of a state entails its international responsibility and gives rise to an obligation to make full reparation. The draft principles reaffirm the applicability of this principle in armed conflicts and in relation to environmental damage, including pure environmental damage. But there are also a number of draft principles that complement this fundamental rule and address the issue of remediation from a pragmatic point of view. These are related to sharing of and granting access to environmental information, post-conflict environmental assessments and remedial measures, as well as relief and assistance. Most notably, these draft principles are not only addressed to the parties or former parties to conflict, but also to other states and international organizations that are in the position to provide information or remedy. The ILC work, the ICRC guidelines, and other recent initiatives show that there's a new momentum for strengthening the legal protection against environmental destruction and degradation related to armed conflicts. The legal developments are part of wider efforts to ensure that the environment is no more an overlooked casualty of war. Thank you for your attention.
Thank you very much, Marja. Thank you very much for walking us through all these international initiatives and, of course, of highlighting the potential of the International Law Commission's work. I'm sure we will touch upon this issue later at the Q&A session. Now, I would like to move on to our second speaker, Daniëlla Jong. Daniëlla is Associate Professor at Leiden University and Director of the LLM Regular Program at the Grotius Center for International Legal Studies. She is also a member of the International Law Association's Committee on the Role of International Law in Sustainable Natural Resource Management for Development and of the International Union for Conservation of Nature Specialist Group on Peace, Security and Conflict. Daniëlla will be talking about the impact of natural resources on environmental security and the rule of law. So please, Daniëlla, the screen is yours.
Thank you very much, Stavros, also for introducing me, but also for inviting me, of course. So my presentation today is going to zoom in on a very specific problem, and that is the illegal exploitation of natural resources as a means to finance armed conflict. And you may also be familiar with that, and now I hope that the PowerPoint is working, but actually I don't seem to be able to switch it to the next slide. So maybe I can ask yes, exactly. Thank you very much. And so you may be familiar with the issue of conflict resources. So conflict resources, in fact, refers to this illegal exploitation of natural resources as a means to finance armed conflict. And these resources can be found in a number of different products, including your phones. And in phones, you can find tantalum, tungsten, tin, but also gold, minerals that can be found only in a limited number of regions, including, very importantly, the Democratic Republic of the Congo. And this illegal exploitation of natural resources impacts on environmental security and the rule of law in several ways, including because often these minerals are exploited in what we can call biodiversity hotspots. So places that are incredibly rich in biodiversity. And of course, you can imagine that, especially when it's armed militias exploiting natural resources, that this has a huge impact on the environment. But of course, also more generally, because these natural resources finance armed conflicts, they have an important impact on security and the rule of law in conflict regions. Particularly, and then I'm going to ask for the next slide, thank you, particularly important observation is that these conflict resources, of course, are mined in particular regions, including in conflict regions, but that the supply chain is actually global, with smelters being an essential link in that global supply chain, because as soon as the minerals are processed by smelters, it is not possible anymore to trace their origin. But of course, in this whole supply chain, there are a number of actors that do not take responsibility for purchasing natural resources and for certifying the origin of these natural resources, and that's how they end up in consumer products. So that raises an important question for which I need the next slide, and that is, who should bear the burden? And so, of course, the states in which these natural resources are exploited by these armed militias have a responsibility, but so do, for example, neighboring states and other states that are used as part of smuggling routes for these natural resources, and ultimately also the states, and very importantly the corporations in these states that actually produce the final consumer goods. So that's a very important realization. While looking at it from the perspective of international law, on the next slide, there are several avenues that we can take to stop illegal exploitation of natural resources from funding armed conflicts. And a very first avenue is through international criminal law. Pillage is prohibited under the law of armed conflict, but it's also a war crime under international criminal law. So pillage is in fact a particular form of theft. In that sense, looking at natural resources, they belong to the states. So this can be an important avenue to hold members of armed groups criminally accountable for exploiting natural resources that belong to the states. But can we also use it to hold governments responsible, or members of governments? So can they also commit pillage? And if we consider that governments represent the state, you already see that there are certain limitations to using pillage as a response to illegal exploitation of natural resources. In addition, looking at corporations, when these corporations directly buy from armed groups, you can say that they may be indirectly also pillaging, but what if there are a number of other corporations in between? So what if we look at the major global electronic players, for example, without mentioning any names? And so can they also pillage? And so should they be aware of the origin of the minerals? And if they are not, do they commit pillage? So you see a number of limitations and challenges that are inherent in pillage. An alternative way of approaching illegal exploitation of natural resources is by looking at it as contributing to a threat to international peace and security. So of course, because we look at these natural resources as means to finance armed conflicts, they contribute to maintaining a threat to international peace and security. And that's where the UN Security Council, as one of the primary players in this regard, comes in. If we look at the next slide, we can see that the Security Council has followed a binary approach. So already in a statement, a presidential statement dating back to 2007, the Security Council said that in its resolutions it has taken measures with regard to the issue of natural resources contributing to armed conflict, first by preventing illegal exploitation of natural resources from fueling armed conflicts, and most notably by imposing sanctions, but also to encourage transparent and lawful management of natural resources, not only in the source countries, but also, very importantly, throughout the supply chain. And so we see on the one hand, looking at the next slide, we see, no, one back, we see that the Security Council has imposed sanctions against particular natural resources. These are called commodity sanctions. And also other types of sanctions, such as asset freezes for all those supporting armed groups by purchasing natural resources from them. But of course, these sanctions cannot be effective without adequate supporting mechanisms. And the Security Council has given impetus to the development of certain mechanisms that are essential for stopping the illegal exploitation of natural resources. And the first are certificate of origin schemes. And you may be familiar with one very important scheme, and that is the Kimberley process for the certification of rough diamonds. And so that process has been developed in order to stop diamonds, illegally exploited diamonds, from entering the global supply chain, while giving the states in which these diamonds are found still the possibility to export these diamonds and therefore to use them for national development. And so in that sense, the Kimberley process enables to distinguish between illegally exploited diamonds and legally exploited diamonds. And so that's one way of curbing the illegal exploitation of natural resources. Another one, and I already mentioned that the Security Council has also, for example, imposed asset freezes and travel bans on individuals and entities supporting armed groups through the trade in natural resources. And these entities include, of course, corporations. And for that purpose, the Security Council has pushed for the adoption of due diligence guidelines. And these were finally adopted, or in any case, the most well-known are those developed by the OECD. And due diligence sees to soft obligations for corporations to assess the risk with respect to their purchases supporting armed groups. And so corporations are under an obligation to, keep track of a documentary trail to make sure that the natural resources that they purchase do not come from armed groups. And so those are two ways in which the Security Council has given impetus to developments. Well, for now, what I see as the most important next steps is to, for states, and especially home states, and with home states I refer to the states in which corporations are domiciled to incorporate corporate due diligence in their domestic legislation, to make it an actually binding obligation for corporations. And then related to that, to create liability regimes for corporations for causing environmental harm and human rights abuses, but also very importantly, for contributing to such harm through the illegal exploitation of natural resources by not adhering to due diligence obligations. And so, in other words, corporations would then have an obligation to assess the risks of their purchases contributing to armed conflict, and if they would not, in good faith, assess these risks, that they could be held liable or maybe even criminally accountable for those risks. So that's what I see as the most important steps, and thank you very much for your attention.
Many thanks, Daniëlla. It was a great account of the impact of natural resources on environmental security and rule of law. You highlight also the role of the Security Council and the potential role of corporations. Before introducing our third speaker, I would like to encourage the audience to pose questions in the chat function, but in any case, after the following presentation, we have the time to directly address questions. So our third speaker is Eleanor Beevor. Eleanor is a conflict researcher and consultant for the United Nations Development Programme. She specializes in non-state armed groups and environmental protection in conflict. She previously worked as a research associate at the International Institute for Strategic Studies and as a writer for the Jordanian media site Al Bawaba. Eleanor will address the specific role of non-state armed groups in enhancing or undermining environmental security in conflict-affected areas. Eleanor, you have the floor.
Thank you so much, Stavros, and thank you everyone for these great presentations so far. It's a pleasure to be here today. I think I'm the only non-lawyer on the panel, so sorry about that, and I hope that when I do try and dive into the international legal world, please correct me if I make any embarrassing mistakes. So as both of our speakers have just outlined, we are seeing a very welcome new wave of international efforts, including and especially international legal efforts to protect the environment during armed conflict. And yeah, it's very encouraging to see states and international organizations really engaging with this topic. However, the stubborn fact remains that the enormous majority of contemporary armed conflicts are not being fought between states, but between states and non-state armed groups, or between two or more non-state armed groups. Depending on how we classify an armed group, we can identify hundreds around the world. To give you an example, the ICRC counts over 600 as threats to their humanitarian operations at present. And it's also clear that this number is growing. There have been more armed groups created in the last 8 years than there were in the previous 8 decades. Some international parties kind of acknowledge that these groups need engaging if we are to try and protect the environment in most conflict zones. Some are much more enthusiastic than others, but I think that that acknowledgement of the need for this is still grudging, and in certain places still extremely contentious. There's a very limited pool of ideas about how this might even happen and what roles non-state armed groups might take on. And importantly for our topic today, I think this is an area in which aspects of the rule of law diverge from environmental security priorities. Now, given the diversity of ecological environments that armed groups operate in today, there's obviously no single approach to this problem. In my opinion, we do have a diversity of options, but these are going to be hugely dependent on what you want to do, whether it's restoring a degraded ecosystem or trying to protect an existing but fragile ecosystem that's exposed to the dangers of conflict. It's going to depend on the nature of the armed group, and particularly the nature of that group's relationship with civilian communities. Essentially, any one case of an armed group and its relationship with the environment that we examine is going to need numerous extremely specific questions answered. But I do think that there's a general question that's important to start by asking, which is, how do non-state groups perceive the environment in relation to themselves and in relation to their aims? Do they think environmental presentation is important? Conversely, do they think environmental destruction works to their advantage? To what extent do they understand and appreciate the dangers of environmental destruction to the communities that they live among, and indeed to their own objectives? And how long or short term is their thinking around environmentalism, if indeed that's something they even think about? I've had a few conversations with members of national armies that suggest that thinking around environmentalism is still extremely limited, which is why the ICRC guidelines are a very welcome development. But if there is still a tremendous shortage of thinking among state armies, I'm not sure how much we should expect from non-state armed groups. But anyway, this is still a very understudied topic, and we're typically working with hints about what non-state groups think of the environment rather than any clear answers. But there's a few sort of interesting examples for consideration. When Yemen's Ansar Allah Houthi movement blocks access to the leaking FSO Safer oil tanker, it appears they see this both as a means to gain leverage with international actors and possibly to make some money. I think the question here is to what extent they appreciate the scale of what they're risking. Have they considered how this vast oil spill is going to affect Yemen's coastal communities? And in turn, how will it affect those communities' relationships with the Houthis? It's estimated that 126,000 people working in Yemen's fishing industry could lose their livelihood if the tanker leaks or, worst case scenario, explodes. How is this damage to the Red Sea going to affect the Houthis' relations with Yemen's neighbours or Yemen's economy? That's one very novel example, but there's a few other examples, conversely, of armed groups speaking more in favour of environmental protection, although we always have to retain a healthy scepticism about how genuine that sentiment is, or at least how far they're prepared to take it. So in 2017, the Taliban leader, Hibatullah Akhundzada, issued a statement describing the spiritual importance of stewardship and conservation of the natural world, and he called on followers of the Taliban to plant fruit trees. However, Taliban insurgents are very heavily involved in deforestation and the illegal timber trade in provinces such as Kunar, and increasingly so is the Islamic State Khorasan province. They also rely on taxes from agriculture to fund their efforts, which means that civilians who rely on the wood trade for their livelihood will likely have to fund the group, whether they would like to or not. Al-Shabaab in Somalia famously banned plastic bags in 2018, supposedly on environmental grounds. Though again, their environmentalism is at the very least quite selective, given not just their heavy involvement in the illegal charcoal trade, but also the fact that cattle make up the cattle trade makes up a massive chunk of Al-Shabaab's revenue, and that's threatened when cows die by ingesting plastic bags. Now, I don't want to say that non-state armed groups are never sincere when they express a desire to protect the environment, but I think these examples sort of go to show the many challenges of trying to deal with them. For one thing, what leaders say won't always be what their followers do, particularly when it's a large, fairly decentralized organization whose membership is fluid and that have competing interests and loyalties, such as the Taliban. And I think it also goes to show that armed groups are certainly not unique in neglecting environmentalism when it's no longer profitable. We obviously also have to address the ethical challenges of engaging non-state armed groups. I think one of the regular criticisms of engaging them is that it can help to legitimize their claims or to empower the groups. In my opinion, that's not always true, but it's certainly right to question whether we inadvertently treat these groups as community representatives of the civilians that they live among. It's important to ask, would that armed group directly benefit from environmental protection efforts? Although I think it's equally fair to ask whether a predatory state would also directly benefit. So what are our options? I mean, we can certainly look at adapting the existing tools of non-state armed group engagements that aim to make them more accountable to the populations that they live among. So known broadly as soft law instruments, these can be codes of conduct, unilateral declarations, and so on. And they're typically commitments either made by or elicited from non-state armed groups to try and get them to respect international humanitarian law or other more tailored forms of international human rights law. Since these are not legally binding documents, they can be adapted quite easily, including to contain aspects of international environmental law or international human rights law. Again, within these schemes, there needs to be a way of holding these armed groups accountable to the commitments that they make. There's a couple of very rare examples of armed groups being given semi-official roles in environmental protection, such as the Karen National Union in Myanmar signing a memorandum of understanding with the WWF to prevent deforestation, though I don't think that that's going to be an example that can be widely reproduced. We can push for greater environmental awareness among non-state armed groups and the populations that they control. Personally, I don't think that ignorance is among the most serious drivers of environmental degradation in conflicts, and actually particularly poverty and a lack of other alternatives are much more important factors. In my view, the richest ground for opportunities lies in working with the civilians living in non-state armed group controlled areas. Civilian populations often have much more influence than you might expect over armed groups in their area, and where possible, very careful processes of consultation with all parties might yield some interesting avenues for ecological restoration or for environmental protection. However, as I said, unfortunately, this is an area in which boosting environmental security and the rule of various bodies of law don't always see eye to eye. Obviously, international humanitarian law does bestow numerous obligations on non-state armed groups, and the ICRC certainly argues that there are aspects of environmental protection in that. However, other bodies of law, such as international terrorism financing legislation, makes engaging those armed groups extremely difficult, if not sometimes impossible. There is, I think, growing pressure from the humanitarian field to ease these pressures and to allow aid workers to operate in armed group controlled areas. And it would be fantastic to see similar considerations for environmental actors to allow them to work more effectively in conflict zones. But just to finish on quite a nerve-wracking example of this, the United States is about to launch a review to consider designating the Houthi movement an international a terrorist organization. If they do, a settlement on the FSO SAFER may prove impossible because I believe, and I'm sure that there's legal members of the panel who are better equipped to address this than me, but I believe transferring the many funds from the sale of the oil will be illegal under American law and will have quite severe impacts on the implementation of that agreement. I will leave it there and hand it over to questions, but thank you very much.
Many thanks, Eleanor. It was a very incisive overview of the role non-state armed groups may play in relation to environmental security and rule of law. Let's now move on to our Q&A session. I see that we already have some questions in the chat. I will address them to the speakers following the request of our participants. And then now I'm addressing the audience. If you have any more questions, please raise your hand and we'll pass the screen to you. So let's start by the chronological order, by the order of appearance. The first question came from Christian. He has a very important question, contextual question. What are the common forms of environmental harm during conflict? I don't know if any of the speakers wants to pick up this question, or we can just provide a few examples. Marja, please.
Thank you very much, Stavros. I think it would be useful to refer to the post-conflict environmental assessments conducted since the 1990s by the UN Environment Programme, the World Bank and others. There's research based on these assessments, and this research identifies 6 principal pathways to environmental harm in conflict. And let me just briefly run them through. First, bombardment of industrial sites and urban infrastructure, weapons, landmines, unexploded ordnance and depleted uranium, as well as direct targeting of natural resources. But also the use of extractive industries to fuel conflict. This is what Daniëlla was talking about, human displacement, and the loss of water supply, sanitation and waste disposal infrastructure. And then there are indirect effects, including the collapse of environmental administration and in general the ability of state and local administration to protect rights and enforce laws. So the shadow of an armed conflict may be very long also in respect to the environment. Thank you.
Many thanks, Marja. This is a very important point of reference we should always bear in mind. I see that we have another question posed by Marja. It is addressed to Daniëlla. If traceability is lost at the smelters, what are the challenges legislating such smelters?
Yeah, that's actually an excellent question, and also a very complex one, I have to say. So if you look at current due diligence schemes, they actually diversify between obligations based on the position that a corporation has in the supply chain. So there are these corporations that are from mine to smelter, and then from smelter to end products. And especially from mine to smelter, there, of course, it's still possible to trace the origin of the minerals. So the smelters are, in fact, an essential linking pin in the middle of that supply chain. So for smelters, what you see is that usually due diligence obligations require them to have documents provided by their suppliers, and they need to check these documents as well, so that we are sure that the natural resources that are smelted actually come from a particular mine. So they need to make this, they need to be able to show that. And in addition, there are on-site visits in smelters. So then there are actually actual visits to check whether everything is in place. And then for the second part of the supply chain, it's mostly that they need to be able to show from which smelter the products come from. So in that sense, smelters are very, very essential in that whole process, and therefore there are additional obligations that are on these corporations. So also in relation to concrete legislation, and you can see that also, for example, in the EU conflict minerals regulation, where there are specific requirements for smelters. So I hope that answers your question.
Thank you, Daniëlla. And actually, there is another question for you by Arthur. He's working on climate change and the rule of law. So Daniëlla, you mentioned that there are various international and national platforms and instruments engaging with corporations. To what extent are the issues you addressed already part of these deliberations? How far have we gone at this point?
Yeah, so there are, both on the international plane and in domestic systems, there are a number of developments ongoing. On the international plane, I think what is important to mention is that there is currently a negotiation of a treaty for business and human rights, but more specifically also relating to these kinds of issues. Of course, that is a slow process, and we're not even sure if that's going to end into something concrete, but it's an ongoing process. But then in addition, and especially spurred by these developments within the OECD, what you see is that domestic states have started to implement legislation. Very importantly, France as an example, but also Switzerland, The Netherlands is not really up to par in that sense, but I think that will come soon, because of course at the European Union level there are also developments, so that will probably then follow rather quickly. But what you see is that they do not all handle that in the same manner. So for some domestic systems this is explicitly part of the deliberations. For others it's more directly looking at liability only for directly causing harm, and not so much for contributing to such harm. So yeah, it depends on the system.
Thank you, Daniëlla. We move on now to Ambassador Lehto. Juan Salgado from World Justice Project has posed the question to you. Are there any working groups set up to follow up on the adaptation of the ILC guidelines for the protection of the environment in times of armed conflict to specific present-day conflicts? How can we operationalize these draft principles?
Thank you. I think I can in this respect refer both to the revised guidelines of the International Committee of the Red Cross and the draft principles of the UN International Law Commission. The ICRC guidelines are quite new. They will actually only be officially launched in mid-November, even though they are already available on the ICRC website. The ILC draft principles have been adopted last year by the Commission in first reading, and there's actually now a consultation period. Interested states, international organizations and other stakeholders have been invited to submit written comments on the draft principles. And we really hope that this will be an inclusive process so that that would be a good sign also for the future implementation of the draft principles in state practice and in the practice of international organizations. On specific conflicts, both the ICRC guidelines and the ILC draft principles are accompanied by commentaries, fairly extensive commentaries. And in those commentaries, of course, references are made to specific conflicts. Thank you.
Thank you, Marja. I saw we have another question by Marja. Many thanks, Marja, for engaging with the panel. It is addressed to Eleanor. To what degree does environmental destruction as a means of warfare, to what extent is that a problem with non-state armed groups? Besides environmental destruction as part of illegal resource trade, should these issues be seen as intersecting problems? What is the interplay?
Thanks, Marga. Yeah, so Stavros, you may know some more examples, correct me if I'm wrong. I can't think of that many examples of environmental warfare on a large scale by non-state armed groups. The obvious one is ISIS torching oil wells to stop the advance of coalition forces. And the interesting thing about that actually was, I think it's fairly widely agreed that that was a bit of a tactical and strategic blunder. It didn't hold off coalition forces very effectively for very long, and it cost them several $1 million worth of oil revenues. So there's, I don't think they got much out of that, but the ecological consequences were obviously horrific, as well as the public health consequences. That is an unusual example, and it is still relatively rare that non-state armed groups have that kind of leverage to be able to cause such a degree of environmental destruction. Possibly the only parallel at the moment is Yemen, in that that much ecologically dangerous substance is concentrated in the hands of one conflict actor. I think the much more common problem caused by non-state armed groups in ecological terms is the side effects of the illegal resource trade, as Daniëlla outlined very nicely, though I think it goes it's much more extensive than conflict minerals or the minerals trade. One of the things that is a bit tricky about this, and if I may sort of just respond to Daniëlla's presentation from more of a conflict studies point of view than a legal one, I think the tricky thing is that it's probably going to be whatever legal legal instruments are used in the DRC, it's likely going to be profitable to illegally trade resources, not only for armed groups, but for civilian diggers as well, with much looser affiliations to armed groups. And this is again where it gets tough, where distinguishing between civilians and armed groups in the context of somewhere like the DRC is really hard. And it is, for all the ecological destructiveness of artisanal mining, it is still an extremely large livelihood in the DRC. So I'm not quite sure. There's various schemes you could float, including something like payment for ecosystem services to try and offset the loss of livelihoods. I'm very supportive of those, but again, in the context of armed groups, there's a lot in the context of an area where there are a lot of armed groups operating. Convincing people to make those happen is going to be a bit of an uphill battle, sadly. I hope that answers your question. But yeah, Lucy, yes, they should be seen as intersecting problems. Although I think the ecological destruction of illegal resources is a much more common problem in conflict these days. Thank you.
Thank you, Eleanor. Yeah, that was a great question. We still have some time for questions, and likely we have another very difficult, intellectually challenging question by Christian. Do you feel like the environment community and conflict community are well connected? What are the initiatives, examples to build on, to cross, to bridge that possible gap? And if I can broaden this question moving beyond the environment and conflict communities, also in terms of disciplines, international lawyers, conservationists, people, international relations scholars or practitioners, are we close enough? Are we having a meaningful dialogue? Who would like to take up on this question? Daniëlla, please offer us some thoughts, and then Eleanor.
I'm also going to respond a bit to Eleanor, because that's where I do see that there are indeed intersections between, on the one hand, legal approaches, but on the other hand, also insights from conflict and security studies. Because what you just said, that it's so difficult to distinguish between civilians and armed groups, is one of the reasons why, for the DR Congo, for example, there were no commodity sanctions adopted, but rather, therefore, these very more indirect sanctions looking at asset freezes for those supporting armed groups. And of course, that still doesn't make it easy. I mean, I see the problems, but there you see that there has actually been interaction between insights from these disciplines into the legal approaches. But I think generally there's much to accomplish there still. And I have the feeling that although we do read each other's work, that there's still much that we don't share with each other. So in that sense, that was my part of the answer.
Thank you, Daniëlla. It seems we have some way to go. Please, Eleanor.
Thank you. No, absolutely. That's I certainly don't want to be unsupportive of efforts, particularly at the corporation level, to be more responsible about where they buy their minerals from. But yeah, it is one of the enduring difficulties that I'm not sure we'll ever find a solution to. But no, I think it's certainly true that not only the sort of conflict studies and international legal community, as Daniëlla rightly said, we read each other's work, but I am still extremely nervous trying to speak in legal terms whenever I do. So it's a hard bridge to cross. And I think when the question of to what extent the environment community and the conflict community overlap is a really good one. And it's, I would say that it's increasing, it's getting there, but there's still an extremely long way to go. And I say this with a hefty level of self-doubt as someone who comes from a conflict studies background and got a B in biology at A-level and hasn't studied proper science for a long time. You know, it is trying to ingratiate yourself into the environmental sciences community is tricky to do. But nevertheless, I think it is something that we have to try and do, because there is such an obvious need for an intersection between those two fields. Just to rattle off a couple of examples quickly, I've had a few conversations with NGOs working on ecological restoration and things like agroforestry in conflict-affected areas such as Mali and Darfur. And I asked them, you know, so how do you contend with conflict? And they said, well, to be honest, we don't. You know, that's not our expertise. That's not something that we feel equipped to do. So we work in the more sort of peaceful areas of those, but they don't feel equipped, quite understandably, to deal with the conflict resolution aspects of that. So I really, really hope that there's going to be a lot more overlap between those two sort of sets of environmental conflict practitioners. There are efforts to build it, and if I can just use a quick other example from like the UK's what was the Department for International Development. I've had a few conversations with them about conflicts and climate change programming, and it is still in remarkably early stages and at the very, very broad question conversation level, rather than with a specific strategy or particularly specific programs, which is, I'm encouraged that there's interest in it and growing interest, but it is disappointing to know that we're still here given the urgency of the problem.
Thank you, Eleanor. We still have 3 to 4 minutes. I have a final question addressed to all speakers, but I would like to kindly ask you to be brief about this. It builds on the discussion we're having right now, and of course it's also connected to the title of our session. How far have we gone to mainstreaming the environmental dimension? Does it make sense to mainstream it through the key institutional players? And if yes, should we follow a unifying approach? Which entity should be the most competent one? Security Council, UNEA, UNEP, civil society? Where should we leave this question to be addressed by? I just kindly ask you to be brief. Thank you.
May I begin?
Yeah.
So thank you. What I wanted to say is that actually mainstreaming is already ongoing. A number of states in different parts of the world do a lot in order to enhance the protection of the environment in armed activities and in armed conflicts. The UN certainly is doing a lot. The DPKO, many UN agencies such as the UNHCR, UNEP has been doing a groundbreaking work for a couple of decades already. And I think this is slowly bringing fruit. If you think of the latest UN Security Council open debate, only a couple of states, even though they were important states, big states, only a couple of states made a clear distinction between international peace and security on the one hand and environmental issues on the other, and said that these two have nothing to do with each other. But the organization of that debate and all the contributions of other states were really, really positive. So I would be maybe a bit optimistic.
Thank you. Thank you, Marja. That's a very positive note. Daniëlla, what is your take on that?
Well, mainstreaming is, of course, very important, and indeed, as Marja says, is already happening. I'm personally very happy with the developments within the Security Council, but I also know that there are actors who look at that from a very critical perspective, and even, for example, other departments within the UN working on a humanitarian mission say, you know, why should a UN peacekeeping operation have control over that? Well, it's actually more of a humanitarian issue. So maybe if we start to think in terms more of solutions, that would actually be my biggest hope in that sense.
Thank you, Daniëlla. Eleanor?
Thank you. Yeah, I echo the sentiments of both speakers. There has been a lot of improvement, and I think mainstreaming, certainly at the dialogue level, if you like, is becoming very common. Translating that into action is the hard part, and I think we're still at the stage of having to be creative to try and ingratiate the environmental and ecological dimension into, for example, humanitarian work, into military operations, into peacekeeping missions, and so on. I've had a fair few conversations with particularly the British Army, but other militaries as well, about steps to take. And while I think there's a lot of genuine enthusiasm, there's also a lot of classical military concerns about what this means for their force capability. And so as much as I hope that those are going to be overcome, I don't know how fast, if it's going to be fast enough. So yes, I think it's there at the it's mainstreamed at the level of intention, but we still need to be a lot more creative about finding practical ways forward.
Many thanks for this. I would also like to thank the participants for meaningfully engaging with the presentations. And of course, I have nothing more to add. I would like to close this session with this very positive note, but also to bear in mind the asterisk that we still have a lot of work to do. Thank you all for being here with us.
Thank you.
Thank you.
Thank you.
Thank you.